now. Thank you everyone for joining us today. We're going to get started in just 2 minutes and allow everyone a chance to log in. Thank you everyone for joining us today. We're going to go ahead and get started, and I'll hand it over to ASH Executive Director, Laurent Hubert.
Thank you, Michelle. Welcome everyone to the second of a series of webinars for the public health community that are being held this week, which is the week that the Framework Convention on Tobacco Control Negotiations, the COP9, were to take place, but have unfortunately been postponed because of the COVID-19 pandemic. ASH has been intimately involved with the FCTC and the FCTC process, so it's an honor and privilege for me to be moderating those discussions today and the rest of the week. Today's webinar is co-hosted by ASH, Corporate Accountability International, CAI, and the Global Center for Good Governance in Tobacco Control, GGTC. Today's topic is on Article 19 of the FCTC. This is the article on liability, which states that, quote, for the purpose of tobacco control, the parties shall consider taking legislative action or promoting their existing laws where necessary to deal with criminal and civil liability, including compensation where appropriate, end of quote. Basically calling on countries to use the judicial system to address the tobacco pandemic. During the presentation today, you will hear from 5 great speakers who will address the potential of civil and as well as criminal liability. They will present some ongoing cases, and we will all learn how to potentially use the court system to further tobacco control efforts around the world. Before I introduce them, a very quick housekeeping issue. There will be plenty of time for Q&A, questions and answers after the presentation. Please type them in the Q&A box, which for me, it's at the bottom of the screen on the Zoom platform. And feel free to direct them to a specific speaker. And note that all PowerPoints will be made available to those who have signed on for the webinar. So I want to welcome our first panelist, Daniel Dorado Torres. He's the Senior Latin America and International Policy Organizer at Corporate Accountability International, CAI. And he will provide an overview of Article 19 and address why it is important to advance the use of the judicial system around tobacco in the COVID-19 and post-COVID context. Daniel, go ahead.
Many thanks, Laurent, and good morning, good afternoon, everyone. It is a pleasure to be here. And well, I have been invited to speak about an overview on how Article 19 is envisioned in the lead up to COP9, or what will happen with Article 19 if we were right now in the Netherlands. So I would like to start by saying that life always evolves, and as it evolves, of course, all the instruments and everything that is around it must evolve. And the Framework Convention on Tobacco Control, it is not an exception. And I really believe that Article 19 is on that path. Next slide, please. So saying this, I will briefly want to share a little bit of context on how has been that evolution of Article 19 during the COP process, particularly focusing on the two previous COP, then discussing really briefly if Article 19 continue with that perception or being a dream or is becoming a reality, and finally sharing some final thoughts. Next slide, please. So regarding to the context and development, next slide, please. So thanks, Lorraine, for explaining really briefly all what is behind Article 19. You really saved me time, so I will just jump directly to what was the achievement during the COP7 that took place in New Delhi on 2016. So as you may recall, Article 19 has been very controversial because every time we hear about litigation, lawyers, honestly, that's not something like really compelling at some times, so that parties can start moving forward some litigation actions. And of course, this was a concern during the COP process, and that's why all the parties decide to conform an Article 19 expert group in order to make a revision of all the jurisdictional system, all the legal systems that are around the world. And basically, they report back on all their in all their analysis during the COP7. And basically, what was adopted during this COP was regarding, of course, adopting the report that was provided by the Article 19 expert group. Basically, this report highlights two things. No, as you may recall, when Lorraine was sharing the content of Article 19, it establishes on how parties should be compelled or using their civil and criminal legislations in order to make the industry liable. So the report basically concludes that it was quite challenging in moving forward some issues regarding to criminal law, regarding to the different jurisdictions and how every party deals with criminal liability. But nevertheless, they make a big step saying that this was not the case for civil liability and encourage for the developing of certain tools that can allow parties to advance civil litigation actions. So as part of this report, the COP adopted that the Secretariat must develop a civil liability toolkit, or in addition of that, another recommendation of the report that was pulling forward a legal expert database. And in addition, start moving forward and exploring all the resources to support the parties on the implementation of Article 19. Next slide, please. So in the lead up to COP18, it happens quite several things. I will mention one of them in a couple of more slides, but right here, what I want to share is that recommendation or that mandate on developing the liability toolkit was made by the Secretariat. The liability toolkit was launched in early March 2018. And well, the parties review again how was the mandate going. And they encourage the Secretariat and the parties to continue achieving forward the mandate that was given during COP7 and report back on COP9. Next slide, please. So if if all the successes that has happened right now, if the COVID crisis has not appeared, well, right now we were tentatively receiving the progress on how the mandate of COP7 was has been moving forward. But in addition, well, there will be like some expectations if the mandate of that was given of COP7 should stop there, or parties should start thinking more creatively on how Article 19 can become a powerful tool to make big tobacco pay. Next slide, please. So, presenting, apologize for going so fast on 4 years of a really complex process on how Article 19 has evolved. I would like to share a couple of things that probably could start landing if when we continue talking about Article 19, if we are still talking about a dream or a reality. Next slide, please. So, as I have previously mentioned, early March 2018, the FCTC Secretariat launched the Civil Liability Toolkit in Cape Town, South Africa. This was a really remarkable outline in terms of the progress on how Article 19 is evolving, and start sharing that, well, that dream, when you start reading all those words that are in the treaty itself, well, this tool start providing some guidance for parties to start moving forward civil actions in all the countries that are part of the FCTC. Next slide, please. So really quickly, this slide shows an overview of what is the Civil Liability Toolkit in a really synthesized way. It is an online tool. It provides guidance. It highlights some questions in order that every party or every person that wants to visit the website, the website is in the slides. And basically you start solving some questions regarding to 3 different scenarios that the civil liability gives guidance on. One of those scenarios, I'm really happy that Debby is here and will show, for instance, how start combining something that is online can start to a reality when we start talking about public health recovery costs. The Civil Liability Toolkit talks about that scenario. And well, I really encourage to visit this tool because it's not only a tool that is designed for lawyers, it is a really dynamic tool. That's one of the messages that I want to mention. When we talk about Article 19, I think that we should start going against that myth that it is particularly for lawyers. I think that everyone should be compelled in their own particular experience to make the industry and start calling the industry liable. And you, with another of the presentations, you will start seeing how we can start making the industry accountable. But I will leave it there. Next slide, please. Another example that I want to share on how the Article 19 is becoming a reality, well, is how it has been implemented by some of state parties. Here I bring one of the most recent cases. Debby will explain it in detail in his presentation, but it's how Brazil sues the top tobacco industry in Brazil in terms of starting a litigation for health recovery costs. Next slide, please. And finally, I want to share how Article 19 is becoming a precedent for other international fora. Next slide, please. So I really hope that these two actions show in a different manner the power that Article 19 has and how it has been inspiring, for instance, the climate change international space in order to make big polluters liable, and how what it is behind Article 19, for instance, is inspiring civil society. Here I bring in a really interesting tool in which also corporate accountability has been one of the partners, that is called the liability roadmap. This tool is designed by civil society and a lot of experts around the world to encourage not only civil society and of course decision makers to take actions against the big polluters using all the liability and accountability forms party has on their fora, on their national legislation. Next slide, please. And if this is not enough, also there is another international process that is in motion, and it is regarding to the Treaty on Transnational Corporations and Human Rights. The provisions that this treaty is developing are really looking forward for the experience on Article 19 and are including a lot of provisions regarding to access to victims for reparations, regarding to how to discuss the international forum, to how to access to other jurisdictions, and they have been learning a lot from the Article 19 experience. Next slide, please. And I'm just entered to my final slide. So I really hope that all this background has shown in a really 7 minutes presentation how Article 19 has evolved during the past 5-6 years. Next slide. And this evolution, I really want to say that, of course, has a lot of challenges for the future. So I think, or when I was thinking what will be the final thoughts that I would like to share, of course, probably some of the questions that you may have is how Article 19 is connected with the current COVID-19 crisis and how Article 19 could support the post-COVID scenario. So I really want to say, and as you may can start inferring, liability is a really powerful tool. Liability could provide not only the possibility to make the industry liable for all the tactics that we all are familiarized, but in addition, as you will see with Debby's presentation, how a civil litigation action can provide some of the resources that the public health system needs in order not only to face the tobacco pandemic, also to face the COVID-19 pandemic. The second thing that I want to reflect really quickly is, well, what are the expectations for Article 19 around COP9? And if we should continue with a moderate approach, or we should start dreaming bigger and be more ambitious on what we want around Article 19. I should definitely say that we should start dreaming bigger, and I am one of those that I think are thinking that Article 19 has a lot of potential. For instance, I think that one of the challenges that we have for COP is to start conforming, for instance, some working groups or regional working groups that can start providing the guidance that all the parties need in terms of implementing the tools and work really close with the Secretariat. That probably you have been attending to some previous COP, but the Secretariat has publicly shared that they have been making a lot of advances developing the legal expert database that was part of the COP mandate, and I am really looking forward for the launch of that legal expert database. And finally, I would like to conclude saying, well, how else we can increase Article 19 scope? I will leave this to another of the panelists' presentation, but Article 19 has the possibility to start talking and making a really close dialogue with other provisions of the FCTC treaty itself. As we all know, the FCTC is a live instrument, and we should apply this provision to all of the articles. All of the articles of the treaty should be analyzed as live articles that needs to evolve. And when you hear the other presentations, I'm more than sure that you will start saying and seeing all the connections that Article 19 have with the other articles of the treaty itself, also how we can start advancing criminal liability. And with this, I hope the presentation was clear. I'm more than happy to answer your questions.
Thank you, Daniel. Thank you, Daniel. Thank you for pointing out to those important tools, as well as pushing us to use the litigation and the courts to hold the industry accountable, and also in the context of COVID-19, and also for pointing out the cross-sectional nature of the articles and how 19 can help the implementation of the other articles. Our next speaker is Debby. Our next speaker is Debby Bressler, who's an attorney for Brazil, Solicitor Attorney General's Office, and he will introduce us to the tobacco industry accountability and liability health system legal case in Brazil. Debby, go ahead.
Hello, everyone. Thanks for the opportunity to be here. I'm Debby. I'm an attorney for Brazil, working in the Attorney General's Office, and I'm a part of the litigation team that filed a claim against the tobacco industry in 2019. So next slide, please. First of all, I want to give you guys some context of the reality here in Brazil. We have here in Brazil a universal and free healthcare system. It's similar to the UK system, but here we are in a continental state, so we have a really big system here to cover a lot of damages to the people, and the tobacco products have a huge impact on it. And since all Brazilian society contributes to financing the public health system, we understand that the tobacco industry is imposing a really big undue burden. And with that said, we are not seeking a new kind of financing for our system. We are seeking reimbursement. We are only going after what the cost is that we already have paid to the tobacco treatment diseases. We are taking a law and economics approach. Tobacco, it's a licit activity. It's licit to produce it, to sell it. Even the FCTC doesn't command countries to prohibit it, mostly because it's a social, it's a thing that it's installed itself in our society, and we don't see any room to move so far nowadays. But our understanding is that industry can take profit from it before it pays all the damages they cause it to society and to governments. Next slide, please. So in May 2019, we filed here a major lawsuit, civil action against the major tobacco companies here in Brazil, seeking the reimbursements for those damages. We choose to include not only the Brazilian subsidiaries, but also the main headquarters of those companies. And this mainly because of two reasons. First of all, because we have the clear picture, and the idea is that as they work mostly around the world, the national subsidiaries are more like an operational branch, operational arm of this industry. So if we are taking this law economics approach to it, we have to look for where the control is and where the profits are going. And the profits are going to the headquarters. For example, here they are closed in the stock market, and every profit is going to the headquarters. We are also we selected 26 diseases that we are using epidemiological nexus with the tobacco consumption. We have a variety of studies nowadays that relate to this kind of correlation between the tobacco consumption and the diseases, but we choose the Surgeon General studies mainly because they have a whole history of dealing with this issue, and also because it's really interesting that they are compiling of other studies. So we are really looking at the broad spectrum of what epidemiology has to show for us nowadays. Next slide, please. Also, we are mentioning the wrongdoing, several actions and omissions of the tobacco industry throughout history in the lawsuit. We think that there's an opportunity to disclose those conducts throughout the years. For us, maybe that litigate and are inside this field, the wrongdoings, the denying of the harms of the product, the denying of the addictiveness of the nicotine, marketing for children, the policy of destroying documents. This is all really clear for us, but we really think that, for example, Brazil public doesn't have knowledge of this. So the lawsuit is also a really good way to show that to the people. And mainly because of these wrongdoings, we are asking for more than just the reimbursement, but something called a collective moral damage, which is not a punishment damage because it's not, they don't have any punishment proposition, but there's some things that cannot be put into, we cannot quantify in an exact matter. But we are also asking for reimbursements for example, pain, disease, death, and all the other things that come alongside with the cost for the public health system. Next slide, please. And this, we think it's really interesting and important for us because showing population and civil society, governments about these wrongdoings, we can get a little bit more tools to shape our interactions between these actors. For example, now we are facing big discussions here in Brazil about the e-cigarettes and all these things that they claim to be less harmful and things like that. So we think that it's a reminding of how they operate and because how they did operate and how they continue to operate in this, and it's important for us to shed a light of it. And in this field, filing a lawsuit like this, it's an immediately success in this matter because it's really interesting how a lawsuit like this really give a new opportunity to media, academia, civil society, and everyone to start engaging again and discussing these things that relating tobacco. Here we also have some big common senses that need to be deconstructed, and it's really important to use the lawsuit for it. Next slide, please. As expected, the tobacco industry is using every possible defense in the lawsuit and already showing that the strategy will be to delay the lawsuit as long as they can and also to protect the headquarters. This was something that even though we are really in the beginning of the lawsuit and we expect a long several years of fighting there, this is really clear. And our goal here is to keep showing and seeking conviction of the tobacco and also using every step of this way to also do this kind of promoting awareness about these conducts. Next slide, please. The way that they are presenting the lawsuit, it's mostly like they present themselves in the business. They are really aggressive in that they have the top law firms here in Brazil, and also they come with a lot of legal opinions, but they are not presenting any new argument. They always defend themselves, claiming the free will of the smoker, the legality of the operation, that they pay a lot of taxes and things like that. So everything is in the as expected in that matter. And we think that the lawsuit like this is the perfect environment for showing society the damages that occur and how they portray themselves in regarding to society, because this is a debate that they can't run from. They have to present their defenses. They have to engage in media, and sometimes, so it's a really interesting thing to use the lawsuit as an opportunity, and really in the matter as that all the articles in the FCTC can be correlated in some way. So for example, here we are in Article 19, but we are using them to accomplish in some way Article 2.1, accomplishing in some way Article 5.3. So it's a really interesting thing to do to a lawsuit like this. Next slide, please. And that's it, guys. Thank you very much for the opportunity.
Thank you so much, Debby, for presenting us this Brazilian experience. And you also made the point about this interesting about this correlation between all the different articles of the FCTC. Our next speaker is Kelsey Romeo-Stuppy, who's the managing attorney at ASH, and she will provide an update about current cases against the US FDA, the Food and Drug Administration of the United States, and she will also present the concept of using criminal liability. Kelsey, go ahead.
Hi, everyone. As Laurent said, I'm Kelsey Romeo-Stuppy. My presentation today is going to focus on three things. First, examples of Article 19 in action in the United States. Second, some discussion of how Article 19 could be used for criminal liability around the world. And third, some potential concerns or pitfalls or unintended consequences of Article 19. Next slide, please. First, civil litigation in the United States. To my knowledge, none of the cases I'm going to mention specifically reference Article 19 at any point in the proceedings. And as you all know, the United States isn't party to the FCTC anyway, but they're all interesting examples of civil litigation around tobacco. Many of you are already familiar with the first two, so I'm just going to highlight them quickly. Next slide, please. The first case is the Master Settlement Agreement, the MSA. The Master Settlement Agreement is an agreement reached between 46 US states and the four biggest cigarette corporations in America, Philip Morris, RJ Reynolds, Brown & Williamson, and Lorillard. The settlement was about the advertising, marketing, and promotion of cigarettes. The MSA took a lot of big steps forward for tobacco restrictions. For example, it banned cartoons and outdoor advertising and forbids those countries from targeting youth. The decision also required that the companies pay the states. This happened in 1998, but the decision required the industry to pay the states billions of dollars a year forever. Next slide, please. This is the RICO case. In 1999, the United States Department of Justice, the DOJ, sued several major tobacco companies for conspiracy under the Racketeer, Influenced, and Corrupt Organizations Act, otherwise known as RICO. The claim had many elements, and after lots of twists and turns over several years, in 2006, the judge issued an almost 2,000-page opinion holding the tobacco companies liable. The companies appealed, and the appeals court upheld the judgment. The court has legally determined that the tobacco companies are racketeers. Next slide. This is the FDA case. This is a current case that ASH is involved in. ASH and our partners at the African American Tobacco Control Leadership Council, the AATCLC, and the American Medical Association, the AMA, filed a lawsuit against the FDA for their inaction on menthol cigarettes. For anyone that doesn't know, menthol was left out of a ban on flavors in the United States, and we hope that this case will encourage a ban on menthol. It's different from the cases I discussed previously because this is an administrative case against the US government, not against the tobacco companies themselves. It's still pending, it's still in process, so if you're interested, please feel free to follow the case. We would welcome your support. Next slide, please. Criminal cases. A lot of people forget that Article 19 isn't just about civil liability, it also includes criminal liability. The criminal justice system hasn't yet been widely utilized for tobacco control, but I'm going to mention a few cases that have. Next slide, please. A group in the Netherlands brought a criminal case, which included charges of fraud, manslaughter, and attempted murder. The victim in the case was a young woman, a mother of small children, who became ill after battling a lifetime addiction to cigarettes. Unfortunately, she passed away last year. After several hearings in different courts, the appeals court determined that, in their view, this is an issue for the legislature. However, this case was a huge victory in many ways. It garnered an amazing amount of press and attention. There were over 30,000 people signing on in support. You can see the ticker at the top of my slide there. It changed public opinion in the Netherlands around the tobacco industry. People now think of them as criminals. Next slide. A case was also filed in France on similar terms. Because of the legal structure in France, the complaint went first to a judge who opened an investigation. So that's where that is standing at the moment. Our partners at CNCT are leading that case. So if you're interested, you can look on their website for more information. At ASH, we've been doing a lot of research and writing about a potential criminal case over the last few years. One of our major goals is to get past the straight face test. A lot of times, the first time we bring this up with an attorney or a law professor or a prosecutor, they'll say something like, "What? You can't do that." Then we'll explain our legal arguments and the facts that would support a case, and we leave them with our briefs. And a huge majority of the time, after they review the materials, they're convinced. The law is there. We just need to get the right prosecutor and the right court with political will, and criminal prosecution will become a reality. Before I move on from this, I wanted to mention a resource for anyone who's interested in tobacco litigation around the world. The International Legal Consortium at the Campaign for Tobacco-Free Kids keeps an excellent database of litigation decisions. I think Megan's going to put that in the chat box for you all, but it's a great place to keep track of litigation that's happening around the world. Next slide, please. We're short on time, but I wanted to take a moment to address potential pitfalls of litigation. I'm including myself in this because I'm absolutely guilty of it, but often talks on Article 19 highlight the benefits of litigation without really discussing the risks. I actually think this would make for a fascinating presentation, perhaps a side event at future COP, sort of lessons learned on the risks of litigation. One concern with litigation is time. I didn't mention this case previously, but the class action case in Canada, which many of you are familiar with, has been going on for 20 years. Part of the RICO case, which was decided in 2006 in the US, was that tobacco companies must issue corrective statements about the actual harms of tobacco. The industry delayed in court for 11 years. No matter where you are or what case you're bringing, tobacco litigation is a long haul. Another concern is that this could delay other anti-tobacco work. If a case is pending, advocates, government officials, and others might just wait and see instead of implementing other tobacco control efforts. There's also a concern about unintended consequences. It's possible to spend a significant amount of time and money litigating and not get anything out of it. For example, in the Canada case, they have a guilty verdict, but nothing has been paid to the class action victims yet. Another possibility in litigation is that the industry might win, pushing us farther from our goal. Next slide, please. With all of that said, I'm not discouraging tobacco litigation in any way, just encouraging those that pursue it to go into it with their eyes open. I'm a big proponent of litigation as one tool in the toolbox, and I think that criminal liability in particular is a really exciting path, one of many, to a true tobacco endgame. So with that, I think Debby is up next, and fittingly, I think she's going to discuss the future of liability. So back to you, Laurent. Thank you so much.
Thank you, Kelsey, for presenting both those the various types of litigation from against governments, against the industry, or career liability, as well as the pitfalls, potential pitfalls. Our next speaker is Debby. She's the head of Global Public Health Policy and Strategy at the Global Center for Good Governance and Tobacco Control, GGTC. And she will provide an overview of future scenarios in tobacco industry accountability. Debby, it's all yours.
Thank you, Laurent. On behalf of GGTC, thank you for attending this webinar, and good morning, good evening to all of you. Next slide. The future of Article 19 is bright because tobacco industry has finally admitted that its product kills. Parties to the FCTC has a distinct opportunity to make sure there is justice for those who have suffered the harms from tobacco. Parties need to overcome challenges posed by judicial systems, especially in low and middle income countries. And trends in international law should give us some guidance on expanding our tools. Next. The tools we have are based on practices of countries that have brought the industry to court to pay for healthcare costs. This helped in the development of a civil liability toolkit, which must be urgently used in jurisdictions that can. Based on the World Rule of Law Index database, a majority of judicial systems, especially in low and middle income countries, are corrupt, and the judgments are not effectively enforced. We need to take into account about 80% of the countries that are in this boat. Next, we also need to think about victims that are affected and the range of harms that have been caused. This top infographic shows a list of harms, for example, on the environment, corruption, child labor, human rights, deception, and illicit trade. Next, let's look at establishing a liability regime for the draft UN Treaty on Transnational Corporations, which is being negotiated as an offshoot to the UN Guiding Principles on Business and Human Rights, as mentioned by Danielle earlier. The draft focuses on corporate liability for human rights violations and elaborates on effective sanctions, reparation for victims, access to judicial and non-judicial grievance mechanisms, requiring financial security for companies to cover even future claims of compensation. To learn more about human rights and tobacco control, Ash will be having a webinar on this tomorrow at the same time. Next, we look at the Convention Against Corruption that has 187 parties, where the liability of legal persons may be criminal, civil, or administrative. Parties must criminalize the offense of bribery of foreign public officials, and 16 of the G20 countries have done this. So we have the UK Bribery Act, the Foreign Corrupt Practices Act, and parties are also required to subject legal persons to effective, proportionate, and dissuasive criminal or non-criminal sanctions, as well as to compensate the victims of the crime. Next, let's look at some country practices that implement environmental treaties. These have clear provisions on liability, and hence some countries already have environmental courts. They already have very high administrative sanctions, and then they collect a surcharge from polluters and use the proceeds to establish a trust fund for cleanups. In the case of tobacco, almost all countries collect taxes, and up to 40 countries already dedicate this to some program. Next, we now turn to the FCTC. So the FCTC has provisions, and we could build on any progress in this area. So relevant provisions include those where governments are encouraged to go beyond treaty measures, and those where governments are guided on dealing or regulating with the tobacco industry. Next. The trends on international law tell us that there is a need to expand the arsenal of tools for tobacco industry liability in terms of elaborating on the types of liability, including administrative, expanding the scope of systems, including non-judicial ones, putting justice for victims at the center of determining liability, and identifying compensation mechanisms that work. Next. Administrative or quasi-criminal liability refers to liability in administrative or non-judicial procedures, or liability involving punitive elements as if the offense is a crime. In the field of environment, some agencies impose prohibitive sanctions. Primacy is placed on restitution and compensation. Clear forms of liability is imposed on polluters, and the agency is empowered to administer and resolve cases. Next. Because of the weakness of the judicial system, some developing countries have developed a parallel system. Around 40 countries currently have an environmental adjudicatory body. Human rights bodies have been set up in some countries, and some have agencies that hear labor disputes, and around 55 countries have anti-corruption agencies tasked with investigating corruption. Next, on justice for victims. In 1985, the UN adopted the Declaration of Basic Principles of Justice for Victims of Crime and Abuse of Power. This embodies key concepts on dealing with the rights of victims, including compensation. So a victim is entitled to mechanisms of justice, and this includes restitution, compensation, and proceedings that are expeditious, fair, inexpensive, and accessible. No court conviction is required for this entitlement to apply. This is not limited to judicial proceedings, but also informal ones. And where environmental harms is involved, there must be restitution or even insurance for future harms. Next. In the future, Article 19 should provide guidance on the various types of compensation mechanisms. The UN Principle on the Rights of Victims state that the offender should be made to pay compensation. So for instance, in Sweden, there is a victim support fund that is funded by convicts. The principles also state that where compensation is inadequate, the state can establish a national fund or insurance for compensation of victims. So this would be in the nature of the accidents funds. Next are two examples of country practices in relation to compensation. In asbestos, trust funds were established through court settlements and bankruptcy proceedings arising from lawsuits. These funds cover future claims and foreign claims. This has led asbestos companies to go bankrupt, and almost 70 countries now ban asbestos. Another relevant example is the Vaccine Injury Fund. In about 19 countries, the few who suffer from vaccines can get compensated for injuries, but the many victims of tobacco could not. Most of these are state-funded, but some are funded by a levy on pharmaceutical companies or the product. In many cases, claims are recovered from 6 months to 3 years, and the standard for proving causation is lower than those required in the courts. Next. In summary, in the future, Article 19 will refer to a liability regime that accommodates systems, appropriate for low and middle income countries, and will be informed by practices and policies in the field of environment, human rights, anti-corruption, and the progress in FCTC, especially Article 5.3. Article 19 would be guided by human rights instruments and in relation to ensuring justice for victims. Next. Tobacco-related diseases have killed over 100 million in the past century, and the FCTC is intended to inoculate the world against the vector, the tobacco industry. The current pandemic is a reminder of how big tobacco has ravaged our healthcare systems over the years, and is also a good reminder to hold it liable. One avenue is to go to court, but another route is to levy a tax or surcharge or increase existing taxes to make it pay for tobacco harms exacerbated during the pandemic. This will reduce the number of victims and deaths, and the proceeds can be used to pay for healthcare costs or augment economic recovery budgets or set up victim compensation funds. This will not only save lives and address COVID-19 challenges, but also ensure justice for victims in accordance with Article 19 and international norms. That's my last slide, but in the next one, I have a list of references that you might find useful. And in my thank you slide, I have added invitation to two upcoming webinars, two upcoming events. So in the next slide, you will see our webinar next week on the Global Tobacco Index and our free new e-learning course on Article 5.3 developed in collaboration with the FCTC Secretariat. Thank you.
Thank you so much, Debbie. We're going to move almost right away to in a few seconds to the Q&A, question and answer section of this webinar. But please stay tuned. Also at the end, Amos Hausner, an Israeli attorney and tobacco control advocate, will provide concluding remarks on the topic of the FCTC and the rule of law. So we'll now open for the floor for questions. Please type them in the Q&A box and feel free to direct them to a specific speaker. And note again that the PowerPoints will be available for everyone at the end of this webinar. I'll go straight to the first question, which is a fairly simple one, and I think, Davi, it's addressed to you. But how did you finance that litigation? And however, if others also have some ideas or want to have input on how some of the various litigations can or have been financed around the world, but Davi, you first.
Yes, thanks, and thank you for the question. We are self-financed here. We are the government is taking that fight to the tobacco industry, mainly because we are representing all Brazilian population, which is the ones that are paying for a public health system. So we are using the infrastructure of the government itself to use we are lawyers for the government and for the state, and so we are taking those with our own resources. Of course, for building the lawsuit, we end up with a lot of help, especially in the terms of expertise for other people. But mainly our costs are self-financed. But I must say something that it's interesting how sometimes the environment for implementing Article 19 is not directly regarding to FCTC or Article 19. In Brazil, for example, we have a legislation that class actions, with a few exceptions, have no costs. Even if we lose, we have no cost attached, because our understanding here is that class actions, especially these type, are made to protection of the population. So you cannot be afraid to enter these lawsuits like these. You have to be have the liberty, and in a few cases that the other part proves some bad faith or misconduct or something like that from the claimer, there's no cost attached. So this is a really big thing here of our legislation, that it's a really big facilitator of the lawsuit here.
Thank you, David, for the yes, I would like to others to jump in on that topic. Thank you.
So one thing that we have come up against a couple of times when we've been talking to people about criminal liability is funding, because for a criminal case, it would need to come from the state. So from the prosecutor, either at the state or federal level, depending on your location. And it's tough because the tobacco industry can bury entire United States or entire countries with their financing. But because of the way that the criminal justice system is structured, it's not easy for us to help finance that. So I think it's an important consideration. I don't really have an answer, unfortunately, except that I think in some ways we could pull apart the funding. Funding for communications campaign around a criminal case could be very different than the actual legal work. And I think that's something to consider in this area as well, is that it might be going to different people for different aspects of the funding.
Thank you. And I wonder if Debbie or Amos, if you have anything to add to this, because we're in a situation where the industry has a lot of resources. They use litigation a lot to either block implementation of the treaty or public health policies. And on our side, in terms of resources, where can we, as civil society, as public health community, ensure that we have the resources to follow up with legal actions that advance public health?
Oh, if you ask me, Lorraine, the answer is pretty simple. Article 19 has already become part of the internal legal system of the country. It varies from one country to another. For instance, some countries can be dragged to court because they have not implemented articles of the FCTC, Article 19 included. Regarding the funds required, we can make the situation as simple as possible. For instance, if you are going after them criminally, you do not really have to prove much. Why that? Because tobacco kills 1 in 2 users when the product is used as intended, directed, foreseen by the manufacturer. What else do you need? On top of all that, it is extremely addictive. You do not have to prove much. The trial can be very short. You don't need much. And the effect, I mean, Kelsey spoke before about the pitfall, about the hurdles, about the dangers to the plaintiffs or for the prosecutors, but think about the tobacco industry. If they lose just one case in a criminal court, can you imagine how dangerous this is going to be to the entire industry of trillions of dollars? I guess here is the answer. You do not need much. You can simplify it as much as possible, and you wouldn't need to expend much on these trials. And the state, I'm promising you, all states, like Israel, for instance, is now criminally prosecuting its own prime minister. Wow, look at that. The prime minister is investing a lot in this lawsuit, and still the state is going ahead with this. Okay, so we can solve, and Israel is not such a huge country. So there is an answer. Now, if you look at the Article 19 as a source, as a judicial resource for the government, then it works perfectly, except for the United States, who has not ratified. But ratification of a convention really means that the legislature in that country paid attention to the content of this document. I mean, they're aware of it. It's part of the law.
Amos, can I jump in? I wanted to talk about something you just said, that Article 19 is important, but not necessary. We are also looking into a lot of different other aspects of law. Debbie mentioned human rights law. We also are looking into business law in some places, corporate law, as an angle in. Debbie, did you want to say something too?
Yeah, I just wanted to comment on the fact that it is really challenging financially if you want to go this path, and whether you win or not, it's like filing a case against the mafia, really. Very, very corrupt, very, very hard to win. Of course, if you win, that's big news, but it doesn't stop the mafia either. So I think, but there is a great win if the government is on our side on this. I think that's the key, and that's why Article 19 is important. It depends on the level of support that the government is willing to provide, and it is now dependent on parties on how they will shape Article 19 to be that tool that will be useful, so that it doesn't sound that difficult. Yeah, and I think one of those ideas would be probably, a litigation fund, at least to start people off, or at least some way to really help victims to file cases. Thank you.
Thank you, Debbie. I have a follow-up questions a little bit on this topic, and you mentioned the judicial bodies in various regions and countries. And I was wondering, in the context of the impact that the industry, the tobacco industry, and the right to health of citizens of the world, would it help to link it to the obligations and that countries have to other human rights treaty bodies and human rights treaties that they've ratified in addition to the FCTC? And are there ways of linking both of those? One is to put more pressure on governments or using legal action to increase pressure on governments, but also to attack the industry legally.
Right. Well, most of the human rights bodies are more involved on, freedom of the press, protection from the state, protection from the state when the state does not protect against human rights violations. But having said that, there are human rights bodies that are also strong champions of the right to health. And so they really, really are keen on this issue. And so it's really, I think, useful if we could link to them. And I don't think we've really tried hard enough to map out these human rights bodies and link to them one by one. But there is that opportunity for certain. Thank you.
That's an underutilized.
So I wanted to highlight quickly that tomorrow we're talking about tobacco and human rights. So if this is interesting to people, please join. And also, it's not human rights specifically, but the international legal system is something that we've looked into as well. I know Amos and we've been discussing this for years, but getting into the international criminal justice system is an option as well. And one way we can do that is pursuing domestic level cases and moving them up into the international legal system. Daniel, I think, do you have your mic open? Did you want to say something?
Yes, Kelsey, thank you. I just want to bring again the case of, the current process around the treaty that is being negotiated on human rights and transnational corporations. I think that's a concrete example, Laurent, on how those linkages can start making. And of course, the negotiation of the process. And I'm agree when Kelsey was saying that we should also, if we are talking about the benefits of moving forward Article 19, we should also be talking about the challenges that we have on moving liability. And of course, the liability provisions that the treaty has been one of the ones that has caused more noise during the treaty negotiations. But I also want to share some hope. Imagine if only the industry is afraid of states moving forward litigation. Imagine the power when you start now talking that you will also bring human rights tools to make them accountable in addition with the liability. So I think that that's a good sign. When we hear a lot of noise, I think that the tobacco control experience has shown that probably that's the way that we should continue moving the path. So I will encourage, and I'm really looking forward for the webinar tomorrow to see how strengthening the human rights aspects of the treaty should also support us moving forward that path.
Thank you. We'll definitely hear more about that tomorrow. Before we go to the concluding remarks, I have one question for Debby that came up. It was in the case of the case mentioned earlier. What was the rough amount of the moral damage the plaintiff asked for? And can you explain a bit more why punitive damage were not pursued?
Yes, the collective moral damage, actually, they will be defined through the course of the law. So the judiciary system will define an amount, because at the genesis of it, it's a non-monetary issue. So they have to be arbitrated during the process. And we didn't ask for punitive damage, mainly because our legislation doesn't predict it, the civil liability for that end. Our system is not, there's not legal grounds for it.
Thank you, Debby. I'm conscious of time, so we have now coming almost to the end of the webinar. So for the last 5 minutes for Amos Hausner to provide some concluding remarks as a leading attorney. Please, Amos, go ahead.
Thank you, Lorraine. The issue really is, what is criminal law all about? The purpose of criminal law is twofold. First, it's about punishment. You have to punish somebody for something wrong that they did. Now, if somebody knows for certain that the product this somebody is manufacturing is going to kill inevitably half the users of this product, then is worthy of a punishment. Because this is the way we describe it in criminal law. We describe it as some type of homicide. Homicide can be manslaughter, can be reckless endangerment, but it is some sort of causation of death. This way, the purpose to punish is well exercised by Article 19 and by the criminal lawsuit. Now let's talk about the other purpose of criminal, to deter people, to educate that this violation will not reoccur. This is also very important and can be implemented in Article 19. It's another purpose, it's very important, and as I mentioned before, once such a lawsuit is successful, it can be the nearing end of the tobacco industry. We call this an end game. Now, we spoke before, somebody mentioned that in Brazil, the industry claims that it is paying tax. The industry is not paying taxes. The poor consumer who is at risk of getting cancer, this consumer is paying the taxes, not the company. They are not paying anything. Come on, they're just making the profits. And here we come to the part of the Article 19 that speaks about the civil liability. We are talking about compensation to the medical system and to individuals. The individuals who are put at risk by this industry, and to the healthcare system that serves everybody, people who smoke, people who do not smoke. And this healthcare system cannot provide the most efficient system of health because of the heavy burden on its shoulders due to tobacco. And if this is true in ordinary days, just think how true it is in Corona, in COVID-19 days. We all need these resources. We cannot just sacrifice them for the benefit of these people in the tobacco industry. Once these lawsuits, and here I'm talking about the civil liability lawsuit, once these are won, the states, the countries all over the world will have the resources needed to implement their health policy facing the COVID-19. Thank you.
Thank you, Amos. And I want to give a big thank you to all of the panelists today. And I want to remind everyone that we have 3 more sessions this week. Tomorrow is on incorporating human rights into the WHO FCTC, and we have fantastic speakers. Steve Marks from Harvard. We have 3 speakers from South Africa. Kelsey will speak also. It's going to be a very instructive webinar tomorrow. On Thursday, we have one on COVID-19 and the impact on the FCTC, cessation and tobacco policy. Dr. Adriana Blanco from the Secretariat will join us for this, as well as we'll have presenters from Spain and Martin Rowe, who will present the topic of cessation in the context of COVID-19. And on the last day, we will have a presentation from the FCA on the issue of funding to implement the FCTC. Thank you very much, and please join us for the rest of the week.